Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of our Corporate Counsel interview series. Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution techniques, and to provide an insider's view into how CPR's community of in-house counsel, external counsel, experts, and others in the international arbitration and mediation field are using dispute prevention and resolution techniques to manage conflict to enable purpose. As part of this goal, we're hosting the CPR Y-ADR Corporate Counsel interview series, where I'm inviting in-house counsel to share their perspectives on best practices in ADR and to share their advice for young practitioners. Today, I am delighted to welcome Chris Campbell, who is Senior Counsel Litigation at Baker Hughes, based in Florence, Italy. Hi, Chris. We're so happy to have you here today. Thank you for joining us.
Hey, Lizzie, glad to be here. Thanks for having me.
My first question for you is, can you tell us a bit about your career experience, how you came to join Baker Hughes, and the types of disputes you supervise and manage?
Sure, glad to get into that. So my career experience actually is perhaps I'm one of those business people that got lost and ended up in law school because I started my career at business school and did a little bit of business consulting first, and then went to law school, became a lawyer, started my time actually in China, in Beijing, after I graduated from the Tsinghua School of Law. And from there, I did a number of matters, cross-border M&A in China, along with commercial dispute resolution there for a couple of different Chinese firms. I then worked as a judicial law clerk, then went to work for a local US firm doing civil litigation, some eminent domain and expropriation work. And then I had a chance to work for what was then Baker Hughes GE, and now Baker Hughes, doing a lot of different commercial matters. So that has meant strategic negotiation, mediation, no conciliation yet, but arbitrations, all areas of the ADR spectrum I've had a chance to be involved with during my time at Baker Hughes. And in particular, a lot of the time, especially as an in-house counsel, I had the opportunity to sort of bring those legal skills into a commercial environment as well, as our business colleagues will come to us and say, hey, we're considering doing this thing. Is this legal? Is this compliant? How will this affect our litigation strategy? So that's been kind of a fun way to marry the business experience and legal experience at the same time.
Thank you. Can you tell us about the disputes that you manage at Baker Hughes?
Sure. So the way that our team functions is that each of us has basically a region or a couple of countries in particular that we sort of specialize in, but all of us will be involved with matters in different jurisdictions from time to time. So a lot of the areas that I will work with are in Europe, as you can imagine, being based here in Florence. I do a decent amount of things with China because of my background there, things in the Middle East, more recently things in Brazil, and then of course a smattering or a handful of matters in the United States as well. Really, there's a number of jurisdictions. And I guess on top of that, when we talk about like, I guess the sectors that we deal with, really a little bit of everything except for labor and employment. With that we have specialists in the company that have dealt with that, or we farm that out to external counsel from time to time. But whether it is a breach of contract, or how one of our turbines or some other machinery or equipment was working, we see it all. So I am certainly not an engineer or technical expert yet, but you do get sort of a crash course in all of these things when you're preparing for a mediation or an arbitration.
As a general matter, do you find arbitration to be a good option for all types of commercial claims?
The general answer to that is yes. And I guess we'll get into this a little bit later, but I do think there are some challenges and concerns that the field as a whole, that all of us have to kind of take ownership of in order to make sure that it remains a viable option. But yes, there are times when arbitration is the only way forward. And, it's a huge expense to the clients, to us, to the company, to make that decision, not just in the cost, but in the resources that one must invest in order to do that. So we do try and be considerate and very thoughtful about when we do engage arbitration. But when it comes to making that decision and it's been made and it's time to employ it, then yeah, we're going to go full force.
Do you tend to use a lot of ADR and the various tools in ADR?
Yeah. And I think that, sometimes when people hear ADR, what they hear is mediation, or that or if they hear, and then maybe they're not wrong with hearing mediation, but they have a very specific sort of notion of what a mediation is. An image of a boardroom and the two sides just kind of glare at each other for 8 hours, and then there's no agreement reached. And yeah, if that's what mediation all it was, I might have a negative opinion of it too. But I think when it comes to managing and mitigating a business dispute, which oftentimes these legal disputes are sort of framed as, I think that can be effective. And I think that it gives an opportunity for both sides to really sort of have a sober look at the strengths and weaknesses of their case. And if both sides are in good faith negotiating with each other, I think you can reach a resolution. Sometimes it's just a reality where both parties just strongly feel differently about their facts, and that's okay. But I do think a mediation is just almost invaluable to making sure that both sides at least understand where the other is coming from.
What do you see as some of the challenges of negotiating a dispute resolution clause?
I think it's maybe a double-edged sword. One, being uninformed, but two, being too informed. That is to say that if you have someone that has no concept of how dispute resolution works practically in an international context, you can end up with these really sort of strange clauses that might call for a tiered dispute resolution process that, the parties will negotiate for 61 days, and then they will go to mediation for 92 days. And, just weird things will sort of prop up, and you'll have a venue in one place, but then the seat of arbitration or the seat of the dispute will be 2 or 3 different places throughout the course of the tiers that can be. So that those are some of the things that become challenges when you're talking about not in a pejorative way, but an ignorance of how the practice actually works, or just really being insistent upon certain provisions, saying that, okay, the entire rest of the contract is governed by one set of law, but then disputes specifically will be governed this other way. I mean, I think that those are things that kind of just invite problems unless there's a really good specific reason why that's the case. On the other hand, when you have people like ourselves that are really in this arbitration dispute resolution world all the time, I think sometimes, they're playing 4D chess when quite literally the other side is just like, we don't need anything quite that complex, and we're not trying to talk about all of that. And I think especially from a private practice standpoint, you can sometimes be trying to sell someone a really advanced, really complex clause, and it's just the contract itself isn't that complex. And adding a dispute resolution clause like that can just add more difficulty and frustration to the entire situation.
You mentioned the usefulness of mediation earlier, and then also the challenges of a multi-tiered dispute resolution clause. Do you tend to find it helpful to have a clause requiring mediation, say before arbitration?
Yeah, I think that it's well, and I know that this will be maybe a little bit of fence riding, but I think it depends on the situation. I think that, if it's a high value case, or it's or a potential dispute or a big contract, I guess, or it's between sides that are just getting to learn each other, then yeah, I think that can make a lot of sense. Because, if one side kind of just feels aggrieved about something and wants to charge into an arbitration, that's bad for both sides. Even the side that's ultimately right at the end, you've now taken up a lot of time, resources, and money in order to sort of jump right into that. Whereas at the end of the day, frankly, if you're going to go to an arbitration, a mediation is going to be a speed bump along that way if you have one side that's set on doing so. So most times, I think it does make sense, whether you're really familiar with the side or you don't know them at all, to put in some sort of requirement that you at least have that sort of cooling moment. But of course, it depends on the specific situation between the parties.
Absolutely. And assuming that you proceed to a dispute, mediation or arbitration, and you're looking to hire external counsel, what are you looking for?
What are we looking for in external counsel? Let me add one more thing, I guess, to my previous answer, and then I'll jump right into that question. I do also think that whether it's because of external counsel or some other force, there can kind of be this tendency to once a dispute has come up, to really sort of get tunnel vision on your own facts and to fail to put yourself in the shoes of the other side. And I think that that's dangerous because you kind of overlook the reality of how a neutral might see the case, or where there's a legitimate opportunity to sort of resolve things. That if you only assume that you're right, then you don't see the pathways to sort of resolution that might exist. And I think that that is something that I encourage everyone, whether you're in-house or external, to do, is to say, all right, before we really start, sharpening the swords and really charging at these folks, I mean, have we really examined this dispute in all ways that can be, and do we really understand their case? Because I've had instances where you end up at the point of where both sides are about to pull the trigger on arbitration, and then you realize, because they finally stated the definitions of their case, that they were talking about something else altogether. And then you can kind of say, oh, well, hold on a second, let's talk a little bit. And then the case ends up resolving. So I think I really felt it was important to make that point for the folks at home. To your question, what do we look for in external counsel? Now, I cannot reveal all of the trade secrets or any of the trade secrets, but what I can say is that here are some of the things that are important to us. I think showing and indicating or demonstrating that we're not just receiving your law firm's brochure in terms of the dispute that we've brought to you. We get it, especially if it is a large organization, there are some things that you have standardized, but especially as a business client and a large corporate client, almost no two disputes are exactly the same. And when we brought it to you, we didn't expect for it to be treated the same. So it's a little disappointing or frustrating when you talk to an external counsel who will have 10 pages about their firm generally, or just kind of some general advice, and then 1 page about like the legal analysis of your situation and what their strategy is for taking it forward. I know that is certainly something that, whether it's us or I think a number of my colleagues that are also corporate counsel, that's something that is kind of disquieting when it happens. Not just because it's a hot topic, but because it's something that Baker Hughes has valued for a long time. And especially as a person of color working in this field, diversity is extremely important. The gender context and the racial and ethnic cultural context, ableism, ageism, all these types of things are critical. And that isn't to say that every law firm or your entire team needs to have tick one of these boxes. That's not what we're saying. But what we are saying is that if you work in a diverse market and your team is only one gender or one ethnicity or only of one type, then it matters to us because it makes us concerned about the ability to sort of properly analyze and think through and ultimately resolve our case. We don't want diversity for diversity's sake. We want it because we think it's ultimately going to help us win. And that's true both for the teams that are proposed as external counsel, but also when we're asking our external counsel to pick mediators and arbitrators, and then you end up with all of one type of person. That just it makes us feel like maybe due diligence wasn't done in order to sort of arrive at that conclusion. I think transparency on pricing, that's maybe that's a stereotypical sort of corporate counsel answer, but yeah, I mean, at the end of the day, we have corporate clients internally that we have to answer to and explain and justify the cost. And if we don't understand it, then we can't do that. And so I think that it's just good to be clear about how things are going to be allocated and charged and all of those types of things. And I guess I reiterated, maybe this is another way of saying what my first point was, but I think being, showing that you've thought through the problem, not that, this is something I found on Westlaw in like 10 minutes. And here it is, really, like, what are the timeline milestones? How are we going to make this case? What's the route to victory? All of those types of things are critical to understand when we receive a proposal. And finally, follow directions. If we ask for certain things in our request for proposal and then you don't include them, that is definitely not a good way to start the conversation.
It's really heartening to know that Baker Hughes takes so seriously diversity. And you've mentioned a little bit already about the factors you look at when you're appointing mediators and arbitrators. So in addition to diversity, what other things are you looking for when you're making those appointments?
I think familiarity with the issue that we're talking about. Obviously, do you have to have very specific, like you've done a case like this previously? Maybe not, but if we're talking about a construction dispute with some subsea equipment, or it's an oil and gas or some other energy type dispute, and then you send us your IP partner, or you send us, your aviation lawyers or something like that, it does kind of make us feel like, are you paying attention to the needs of this case? I think how the time is allocated is maybe that's a more nuanced point. It's usually the one when you get the call from the in-house lawyer saying, hey, we need to talk about the bill. But if you have an associate billing X amount of time to figure out an issue, when you know good and well that the partner could have figured that out in a quarter or a fraction of the time, yes, we understand and we're sympathetic to the fact that lawyers need to train, law firms need to train their associates, but we're a business. And unfortunately, that's not part of our value statement. Our mission statement is to train external counsel. So, I think that most reasonable in-house attorneys understand that, there might be a little bit of greater efficiency with partners versus associates, but you do sometimes see these bills where the hours are vastly out of whack, and there's very little justification for it other than, oh, this person just did the work. Why? So those types of things. Yeah.
I'm really glad that we're having this conversation via Zoom, and pre-pandemic, I don't think that this kind of interview we're having would be that common. So one question I have for you is, have you, in any of your cases, have you participated in a virtual hearing, and what was your experience with it like?
Yeah, it almost kind of coinciding with the world shutting down back last March. Quite literally, I had a virtual hearing after I'd already traveled to the location, because what had happened was opposing counsel did not want people that had just flown us in their offices because of COVID. And so we ended up having traveled to the UK and still having a virtual hearing. So that's how we literally got started with it as the world went. I think this was like the first or second week of March last year. Yeah, I'm a big fan, and I think that that's going to be the trend that we see going forward. There's just not a practical need to travel probably as much as we were previously. Even witness testimonies or witness sort of prep, I think if it's an extremely technical point and it's something that's going to take a long time, maybe you need to go there and be in person. But I think if it's just a 1 hour meeting that probably needs to be had, or, if someone lives, if you have to both be in Paris and Australia in the same week, then yeah, one of those can absolutely be a virtual hearing. There's not a need to be face-to-face all the time. I think that was even an issue in the Vismoot problem last year. I think that the days of always needing to be in person are numbered, and I think you're going to see more and more of this going forward.
You mentioned earlier that you manage, a large number of disputes, basically everything other than labor disputes. So how do you see your role as in-house counsel when you're managing a dispute, and how proactive are you in arbitral proceedings?
So I do know, and this is, I guess something that our team here at Baker Hughes probably has a reputation for, is that we are pretty proactive. There are times, and just the realities of life, where, we don't have time to be as active in every single case as we might be on some others. And those are the opportunities where we engage with external counsel. But, there's a certain valuations that we have internally that if the case is not too complex and it's under this valuation, then we're probably going to handle it mostly in-house, in terms of, making submissions in mediation, making submissions in arbitration, and appearing before the tribunal or the mediator. On the other hand, if we do engage with external counsel, one of the things that allows us to be really effective in terms of cost efficiency, even success rate, to be quite frank, is that we do try and be as engaged as we can. That, do we need to talk every single day or necessarily every single week? No, but the external counsel that we work with know that we expect, to be kept in the loop about what's going on, and, how can we help, build this case. We'd like to review the proceedings. There's sort of this, stereotype or cliche that when you go in-house, your proper legal skills, in terms of drafting or being able to be an advocate. sort of dull. And for us, that's just not true. We have the opportunity to do a lot of these things so much that it is almost working for a law firm within a company.
I also agree that it's really great having parties be more involved in arbitral proceedings and dispute proceedings generally. So for example, being CC'd on communications from the tribunal or participate in case management conference, because this means that, external counsel are always aware of the commercial priorities of the user. And one specific related question I have for you is, how often do you consider settlement in the course of arbitral proceedings?
I think again, I guess it kind of depends to some extent, but our way of seeing it is that we want the result that makes the most sense. And we're not going to fight an arbitration or entertain an arbitration or even go to mediation just for the sake of saying we did it. If there's something that we haven't relented on, or that we haven't kind of ceded to the other side, it's because we feel pretty strongly about it, and we feel like we've got documentation and expert support to support those positions. But if at some point a smoking gun or something that kind of takes out one of the pillars of our argument is taken out, then we're not going to just say, oh well, keep same point, press straight ahead, steamroll. No, I mean that's ridiculous, that's silly, and that's a waste of everyone's time. At the end of the day, we're an energy company, we're an energy technology company, and that's what we'd like to be facilitating and supporting. So, we're not a law firm, and we're not out here trying to just have legal disputes for the sake of having them. If we're having them, it's because it's critical and essential that we make these points.
You talked a bit before about virtual hearing and some cost efficiencies. And if you need to travel, consider whether you need to do all of the travel, and consider doing it online. So let's talk about arbitration and the environment. Do you think there's more we can do here?
There absolutely is. Look, anyone listening to this knows good and well that there was a lot of things that we just had as an industry, and I think that the world is still as a whole is grappling with about how we could be more cognizant of the environment. Do you need to have your computer always on and running? Do you need to print in bundles and bundles to go to a hearing? I mean, I think a lot of arbitrators and more senior lawyers before the pandemic would have said, yes, absolutely, we need to have the entire set of bundles. Well, now they have the tablet, and the tablet is just as good and sometimes better than the hard copies. And I think that's a really easy one. I think the carbon footprint associated with, as we talked about a moment ago, flying all over the world on a weekly basis. I mean, it's a bit irresponsible. It would be tantamount to having the hose at your house just running constantly without needing any specific need or desire for it. I mean, I think that those types of things are things that we can ultimately be more thoughtful about, even flying for conferences. I mean, we all will look forward to, once the pandemic is over, being able to see our friends around the world. But we've got to be a little bit more smart about it. We can't do these things, 2-3 conferences a week in different places and all that stuff. And there's some really great voices from Greenwood Arbitration with Lucy Greenwood and her initiative at the Green Pledge, to Annette Magnuson over at Climate Change Council and her colleagues. And there's another number of great initiatives supporting that. And I think it's because it's becoming so critical that we've only got one planet, and unfortunately we've not treated it the best. Absolutely,
I completely agree. You mentioned earlier the importance of diversity when you're appointing external counsel. And there's been a lot of diversity related initiatives recently in our field. Is there more you want to say on this topic?
Yeah, one of the things that I talked about in another interview recently, and I think that this is really the only way to get some accountability, is I think, look, all of us have some business background, or we're very results driven and metrics driven field. So it shouldn't be any different when it comes to diversity and inclusion. If we really want to see it, if you really want to see clients be accountable, arbitral institutions be accountable, then we need to establish some standards. And with those standards, there'd be something like, an annual audit of what your diversity initiatives are, how they're paying off, and what the results are, and 3, what you're going to do next. I think that something like that would allow us to be able to have a common language and a common set of apples to apples comparison of what diversity means in the context in which you're measuring, and two, how it's progressing. Because I appreciate that diversity and inclusion in the United States isn't the same as it might be in Portugal or in Hong Kong or Vietnam or London. They all have different contexts. And so we have to come up with some sort of, standardized way of talking about it, and then establishing how we're going to measure those things. And I think that that's what I would challenge everyone listening, whether they be institutional as a client or an arbitral institution or a law firm or any of the organizations that purport to be, big on diversity. Okay, if you're big on diversity, show us what you're doing, show us how it's working, and tell us how it's going to continue.
I think 2 points from what you've said really stood out to me there. And one is having, a complex understanding, or not a nuanced understanding, about the meaning of diversity and recognizing, all the different diversities that are important to our field. And the second one I think you make about accountability is very important. And I think we're seeing beginnings of that. I think in the GAR 100 form, there is now a question related to what your law firm is doing on diversity measures. And I think it would be good to develop more accountability standards, as you mentioned.
Yeah, and I think everyone has their part they can play. For a student or for an individual, maybe that's supporting other initiatives that are going on, or writing about it, or kind of speaking and using your voice that way. But from a client perspective, it's I wouldn't say that we have this maybe sort of zero tolerance policy, but I would say we absolutely notice whether or not diversity has been something that's been considered by vendors that we work with. And if it's not, that is something that we talk about internally. So I think that that's the direction that clients are going to have to go, is to say, if we really care about diversity, and it's not just virtue signaling, and saying, look, like, hey, you're a great firm, you're a great institution, you're a great vendor, but you don't match our values and we're not going to work with you. I think that that's what people start to understand. I think that's what brings changes. And I think that's what everyone has to find whatever that sort of lever is for them, and you need to pull it and stand by it.
I think that's a really great point. And I think, users of arbitration and mediation can play such an important role in pushing diversity and pushing for diversity when they make requirements of external counsel to have, diverse teams, and to also impose consequences if those aren't met. And this is actually a point, like the role of in-house counsel in promoting diversity was something raised in the ICA task force report on diversity. So I'm really glad that you raised it. My next question for you is, if there was one thing you could change about commercial arbitration, what would it be?
I've been saying this for now a little bit more than a half decade, and I say it, I will continue to say it and say it louder, is that we really have to be careful that we are not transforming arbitration into a parallel version of litigation. And that is something that we're seeing a slow creep of, across a number of industries and across a number of jurisdictions. There's this tendency to say, okay, this is a dispute, whether it's a small one or a huge one, let's go hire a team of lawyers and let's have 2 teams of lawyers kind of duel it out. Let's have discovery, let's have document production, let's have all these things that are already available in litigation, because there will be a tipping point, if we're not careful about it, wherein people, clients, us, will say, if I can get all these same things in court and have even more transparency or have more protections, then why in the world would I agree to an arbitration? And I think that that is probably a really fundamental existential threat that I don't think it's not imminent, but it's something that we have to be careful and thoughtful about. And we should stymie any efforts to make arbitration more litigation-esque.
I'd now like to pivot to some questions about your personal reflections.
Okay.
First, what's your advice for young practitioners in ADR?
So I talked about this a little bit earlier. I think the strategy that I like to call this, and it's a little bit of a reference to a sports maneuver, but flood the zone. And what that means in basketball is it means that, if someone shoots a shot and the ball rebounds, you want to get all your players in the box to be able to try and get the ball. Well, in an arbitration context, or for young practitioners as you have contemplated, what that means is that arbitration, international law, international dispute resolution are fields that are extremely competitive. And every year there are thousands of people across the globe that are looking for, frankly, a few number of spots. And every year, not everyone is going to get hired. So the way that you can increase your way of, one, improving your knowledge, and two, getting an opportunity is by trying to be as ubiquitous as you can. Writing articles, both short and long in nature, helping out with projects with institutions in the field. There's a slew of international dispute resolution related fields, whether that be the ABA, IBA, Young ICA. Every single institution has a young chapter, like here at CPR. Get involved, and I guarantee you they have a project that they need help with. Volunteer for it. Don't do it for every single organization, but take on one or two of these projects, and people will get to know your name and you'll stand out. But the idea is creating enough content and simultaneously just genuinely being helpful that there will be an opportunity, or someone will say, oh, that person does good work. Because frankly, that's what it is. It's a way for people to know something about you so that they can say, oh, I vouch for that person. Oh, I'd like to work with that person. I'd recommend that person. And I think that that's the way that you would want to go about it. Just being out there, creating content, being helpful, and just attending as many events as you can. And if, in fact, that, I guess that's the last point that I would say, is it's an absolutely wild time to be coming into the field, because you have the opportunity to be on every continent in the course of a day without having to fly. There are events all the time. Attending those events, all of them usually have a networking component of some kind. Meet a couple of people. Say you want to meet one person a month or two people a month. That will slowly build up, some sort of some cachet within the field, and people know who you are.
I love the metaphor of flooding the zone.
Yeah,
that's really good for young practitioners. I am going to ask you about your podcast, Tales of the Tribunal, at the end of this interview. But before I do so, do you have any advice for young practitioners who are looking to go in-house?
They're looking to go in-house. So similar to my previous advice, but I think the nuance there becomes, so a lot of times people will get the idea of, okay, Chris said flood the zone. I'm going to flood the zone in the law world. Here's the problem. The business people aren't really paying attention to the law world, typically. So what you'll want to do is, getting a credential can help you, an MBA or a specialized degree. That's one way to do that. But another way is, start going to some industry conferences or events that are had. If you want to work in tech, there are a bunch of different tech-related events. And certainly there are organizations for whatever industry you could imagine, whether that's wine or transportation or mining, any of those types of things. Get involved in those things. I mean, it's the same sort of thought process. You want to start reading those industry publications as much as you can, so you're building your knowledge base. And doing all those types of things. And again, they have projects too that you want to help out with. That starts to build your credential in the business world. And so what all that allows you to do, right, is it allows you to have some sort of idea of what businesses do, and then you can start applying for these types of positions. And if you apply that same idea of getting out there and starting to network with people that are in-house, like myself, or people that are made those decision-making abilities, you reach out to them on LinkedIn, you say hello. You don't need to ask them for a job the first time you reach out, but you start, building at least some familiarity with them. And eventually, as you start to move towards that orbit, you get an opportunity to kind of find the right position in-house.
If you could do it all over again, what would you tell your younger self?
Study Mandarin more.
Great advice.
I'm joking. But it's languages I think are hugely invaluable, right? And I'm able to work and communicate in a couple of different ones, but I think that people sort of undervalue that sort of idea, the cultural element, or the ability to sort of connect with people in other languages that will give you opportunities that if you only speak one or two languages, you just don't have that chance to. But yeah, I guess that one, I don't think that I do think that there's no need to try and specialize so early. You have all these, arbitration LLMs now, but frankly, what's going to give you an opportunity to work in dispute resolution is being really good in your home jurisdiction. And then you start trying to trend in the way that we've talked about towards the field. A route will open up if you're doing those types of things. And so I don't think that you need to say, okay, I'm a second-year law student. All I'm gonna do is arbitration. All I'm gonna do is international stuff. All I'm gonna do is all this. Like, you can have varied interests. And I think those different and eclectic sort of backgrounds can really be a strength coming into this field.
I preempted my next question a bit by mentioning your podcast, but can you tell us how our audience can stay in touch with you and find you?
Sure. So I'm really easy to find on LinkedIn, but I also, as Lizzie said, am the host of a little podcast called Tales of the Tribunal, where we talk to people about the world of international law and dispute resolution. We're about to approach the end of season 3. So while we're on that break between season 3 and season 4, we will have weekly episodes called Disputes Digest, where we profile, we have short interviews with people from around the field, but we also cover the news, opportunities, events in the field. And you can find all of that and more over at talesofthetribunal.com.
Wonderful. And I also wanted to mention another initiative that you're involved in called Arbitration Idol. Can you tell us about that?
Sure, I'm glad to talk about that. So Arbitration Idol is a charity campaign that began last year in the midst of the COVID-19 pandemic. And it's a collaboration between Tales of the Tribunal, the Digital Coffee Break in Arbitration with Vinyo Wachtel, and Careers in Arbitration from Amanda Lee. And it is an opportunity for you to donate €1 or more. Any donation is fine as long as it's above €1, for a chance to win a digital coffee with a figure in arbitration or international dispute resolution. We call it Arbitration Idol because it's a parody or a spoof off of American Idol. But yeah, so we have 14 people from all around the world that are leading figures in international arbitration. And so if you're lucky and fortunate, you make a donation, you have a chance to win a digital coffee with them. And I think one of the people on this interview right now actually was a winner. So, I mean, it literally can be anybody, who knows?
And thank you so much. I had a wonderful coffee with my Arbitration Idol, and you're one of our idols as well. Well, it remains for me to thank you, Chris, for your time today and for sharing your insights, and to thank our audience for tuning in.
Sure. Thank you so much for having me. It's great to be here.